Hello everybody, welcome to Law 2022 Online Wills and Probate Shape the Debate with me, Claire Nithsdale from the Solicitors Group. Today we have Professor Leslie King and James Beresford. Today's session will last approximately an hour and we'll cover pre-submitted questions. A recording of today's live session will be available on the website and we will be emailing it out later today as well. So some introductions. So yeah, like I said, we've got Professor Leslie King with us today. She's a leading professional author and lecturer in wills, trusts and probate. Leslie is a former member of the Law Society's Wills and Equity Committee and the Probate and Estates Committee of STEP, and an honorary member of the Association of Contentious Trusts and Probate Specialists. She's also a professional development consultant at the University of Law and cites and lectures extensively on private client matters. As part of the Law 2022 Online, Leslie's sessions include the right tools for the job, tax issues during the administration of an estate. And then we've also got today James Beresford. He's a lecturer specialising in wills, drafting and estate administration matters and helps his clients deal with legacy planning, providing a comprehensive and understandable solution. He has a wealth of preservation specialist focusing on inheritance tax for high-profile individuals and advising business owners on succession planning. He's been presented with 2 Private Client Team of the Year trophies at the prestigious Manchester Legal Awards and is the author of No Will, No Say, A Simple Guide to Wills and Estate Planning, published in 2017. And James' sessions for Law 2022 include helping your client choose the correct trust in their will, making your private client department. So to kick off, we'll start addressing some of the pre-submitted questions. So the first one is for yourself, Leslie. Do you still have a report and pay CGT within 60 days for residential land when it is a simple case which can be dealt with on the informal basis?
Okay, so the question is, do you have to report and pay capital gains tax when personal representatives have disposed of a residential property within 60 days? If you can complete the administration, I'm just trying to work out the question. Okay. Oh, yes, I've got it. Okay, I've got it. So the question is, if you are dealing with an estate on the informal basis, and the informal basis is when you don't have to submit self-assessment tax returns for each tax year of the administration, you wait till the end of your administration period, then you report to the revenue what your income and capital gains for the administration period is, and you work out what you think you owe them in terms of income tax and capital gains tax. And normally speaking, you just make one big payment at the end of your administration period. And that's what I always used to say to people. Since we got the new rules on accelerated reporting and payment of capital gains tax on residential property, there's an extra problem for personal representatives, because you might have an estate which qualifies as a simple estate, so you're not doing tax returns every tax year, but you are still subject to the requirement that if you dispose of residential property, you have got to report and pay any tax that's due within 60 days. So the quick answer to the question is yes, you do have to report and pay your capital gains tax, even though you're dealing with the estate on the simple basis. However, quite often what happens is that you're at the end of your administration period, and almost the last thing that you're going to do is to, let's say, sell the house that the deceased had been living in. So you sell your house right at the end of the administration period, and it may be that you are then in a position to immediately write to the revenue, tell them what the income tax and capital gains tax for the whole administration period is, including your capital gains tax on the disposal of the residential property. And if you can do that and get the tax paid within 60 days, you don't have to do anything separate in relation to the residential land. But that is subject to you being able to report and make payment within 60 days. The other thing which I should perhaps just add is that these rules on accelerated payment of capital gains tax on residential land, it's only where there is a tax liability. So it could well be that the personal representatives sell a residence during the administration period and they do make a gain, but it's within their annual exemption. And if you haven't got a tax liability, then there's no need to report. You're not subject to the rules. Okay, hope that helps.
Okay. Yeah, that's brilliant. Thank you. And James, do you think trust should be considered for every client?
Well, the purpose of the session I did this time round was really an introductory session for people moving into the drafting of wills. And my own personal view is, in practice, firms are still doing the wills that the client says they want, rather than the will that they need for their specific circumstances. And there'll be a matter of reasonings to consider about that. But I see our role as akin to, in a way, a florist. It's a bit of an obtuse reference, I appreciate, but a client will come in and say, this is the bouquet I want, and you should be using your trust knowledge to create that bouquet. So I think in every case, trust should be considered when you are giving your advice, but then dispensed of or used depending on that client's individual circumstances. I think it's very dangerous for firms just to go down a tick box exercise and do the will that the client wants. You do need to be challenging your clients as to what actually they do want. So, for example, if it's a couple, married couple, civil partnership couple with a child, they may say they may want a will leaving everything to the survivor of them, absolutely, and then down to the child. You may think, fair enough, it's a simple will for us, but you need to be questioning the family, seeing what their hopes, fears, and dreams are, and seeing whether maybe a flexible life interest trust would be required. Are they concerned about the survivor of them remarrying or entering into a second civil partner, a second civil partnership, or if they're older, do they need to be looking at the potential impact of care fees or claims against the civil partner's estate should they remarry? So I think in every case you should be considering the use of trusts, but then using your judgment when you're providing advice to your clients as to whether they should or should not be used. And then you should evidence that. And from a risk and compliance point of view, you need to be doing that. I appreciate if your wills are, your price for your wills are £150, you may not think that from a commercial basis worthwhile, but I think to stop you being accused of any negligence, that you have to consider and then show evidence why you've considered and dispensed with it. I don't know if Leslie would agree, with that potted
I would.
explanation.
I mean, I always say to people that really your job is to raise the what ifs. What if this happens, and how would you feel if that happened? And certainly, I mean, most clients are going to be pretty responsive to any suggestion about, well, what about care home fees? I mean, maybe not if they're 25, but, once you get to the latter end of your 40s into your 50s, care home fees starts to kind of, loom quite large.
I think it could also be, it's a sliding scale of risk as well. So, for example, you may have a couple in their 30s with young children, and they're more concerned about the survivor remarrying and then, making a new will in the future to the exclusion of the child from the first marriage. I've always joked to my wife and said I expect her to, mourn me like Miss Havisham for 5 years after I die, and then she can go off and remarry. But that concern, as we get older, will drop, and it will probably move more towards care home fees.
I don't know that it does drop, actually. I mean, certainly in my house, we have a lot of jokes about, my husband marrying the carer, and, that is not at all unknown.
Yeah, exactly. So I think we have got to start at I always start off at the worst case scenario, and then you work back with the clients, because every client is individual in their nature. And this is why in different talks I've done, I really do object to people using will questionnaires. I think client questionnaires as an information gathering exercise is great, because then you can provide the advice to the client when you see them. But I think it's dangerous just to have a will questionnaire that says, what type of will do you want? What do you want to do? Because they don't know. The clients don't know. They only know when you tell them and advise them.
Yeah, I mean, it depends what you mean by a questionnaire, doesn't it?
Yes.
I mean, I do think that it's really helpful for fee earners to have something pre-prepared, which has things like questions in effect, how did the client seem? Were there any problems with memory? And then there's a sort of little space opposite where you can tick and cross, but there's also space for you to put in comments saying, client seemed entirely on the ball, had no difficulty remembering. So as an aid memoir for the person who is conducting the interview, I think it's really useful to have a questionnaire or a checklist. But the idea of just handing it over to the client and saying, right, what sort of a will do you want? No, absolutely not.
So that's the will questionnaire that I really do despise. And I've seen firms that are using it. What do you want to do? Simple will, flexible life interest trust, discretionary trust, and they don't know. Whereas I think using it as an information gathering exercise prior to a meeting or in a meeting, as an aid memoir about, I need to be looking out for this. I think there's great value in that. But I appreciate, we've slightly gone off the question, but so to give a very succinct answer to a very easy question, do you think trust should be considered? But for every client, the answer is yes.
Brilliant. Well, thank you very much. And then back to you, Leslie. Do you have to pay on accelerated basis if property is mixed use, say a shop and office with living accommodation above it?
Okay, so we're back onto the capital gains tax rules for accelerated payment. And when the legislation first came out, it talked about the accelerated rules applying to residential property. And so that left you with a little bit of an issue if what you had was a mixed use property. Easiest example, shop with a flat above it. And we've had some guidance because in the Trust and Estates newsletter for December 2021, the Revenue said specifically that they'd clarified the rules and you only have to pay on the accelerated basis on the residential element. So if you have sold a shop with a flat above it, the accelerated payment rules only apply to the portion of the gain which is attributable to the flat above the shop. Now, that of course leaves you with some problems about trying to sort out, well, I've sold the property for, let's say, £200,000 and I've made a £50,000 gain. How do I know how much of that gain is attributable to the flat and how much of it is attributable to the shop underneath? And I was actually looking at this, and there is some guidance in the Capital Gains Tax Manual. The Capital Gains Tax Manual has got a really useful appendix that they've added at the back, which deals exclusively with these new rules on the accelerated payment of capital gains tax. And there is a section in there on disposing of a mixed-use property. And what it basically says is that the taxpayer does the best they can to work out and apportion how much of the proceeds of sale were attributable to the flat, how much of the proceeds of sale were attributable to the shop underneath, and then you apportion your gain appropriately. And it suggests that you send a copy of your calculation to the Revenue so they can see how you apportioned your gain. But it is only the residential portion that's subject to the new accelerated payment rules.
Okay, thank you. And James, I've never utilised a bereaved minors trust or an 18 to 25 trust. Would that be something that I should consider using them?
I think there's something you should be aware of. Well, not yourself, Claire, obviously, but again, it comes back to my very odd analogy about a florist. I think when your client comes in and says, "This is what I would like to achieve," you need to have everything on your radar to create that lovely bouquet for them. So, say for a bereaved minors trust, there are some inheritance tax advantages. So, if the child dies before they're 18, there'll be no charge for inheritance tax. There'll be no 10-year or exit charges whilst the child is under the age of 18. And for a bereaved minor trust, there's no exit charge on the child becoming entitled to that settled property at age 18. But what that means for a bereaved minor trust is that it's in effect inheritance tax free until they attain the age of 18. For 18 to 25 trust, it introduces a larger degree of flexibility. At 25, there would be an exit charge, which is limited, I think it's 4.2%. So they do have the uses, but you've got to look at it from how you qualify or how a child qualifies under these, and the uses could only assist in rare cases where the parent dies, leaving the young children, and there's no surviving spouse, for example. That's maybe where there's the uses. But I would say if the estate is below the value of the nil rate band, it may actually be better using a discretionary trust because you've got the added flexibility with that. And if, for example, there's issues with the children, drink, drugs, something like that, then, all the nice things in life, you will be able to withhold that rather than giving the money at 18 or 25, you would be able to withhold that money at that time until that either they've grown up or the risk of them squandering it on a good time has diminished. So I think there's something to be aware of. It's not something I've used often in practice, but I think it's good to have on your radar and to use it as a base of knowledge. But in practice, you may not use them very often. Anything further on that, Leslie, would you say?
Well, I suppose I'm just furrowing my brow a bit here, thinking, I bet people have used, in effect, bereaved minor and bereaved young person trusts. They just haven't necessarily realised that's what they're doing in the will. Because if you just leave it, everything to my husband, if he predeceases or fails to survive, to my children contingent on reaching such and such an age, if you've put in, trustees to hold the property,
yes,
you've created a bereaved minor or a bereaved young person's trust. I mean, it may never actually be required because, exactly as you said, if the surviving spouse survives, then they get the property.
Yeah.
But I bet there's very few wills, I bet, for married couples with children which actually don't have a bereaved minor or a bereaved young person's trust in, unless they have something like a discretionary trust.
No, I think that's a really good point, Leslie. You're right. When you said that, I thought, people, you will have done it without realising. Yeah. You won't have gone, today I'm going to use an 18. Today I'm going to do a will with an 18 to 25 trust in. But there's something to be aware of.
Okay, that's great. Thank you.
And I just sort of leap in, from the other end, when you're dealing with the administration of an estate, you need to be able to recognise that you've got a will with one of these things in, because, it will make a difference to the ongoing tax treatment. So everybody needs to understand what they're looking at. Sorry.
No, that was brilliant. No, thank you. Yeah, chip in, Matt, if you have anything else to add to it. Yeah. So, Leslie, if you appropriate property to beneficiaries before contracts are exchanged, will beneficiaries then be liable for capital gains tax on increase from death value?
Yeah. If you're doing an administration of an estate and the personal representatives are going to sell an asset, If they sell it as personal representatives, personal representatives pay capital gains tax at the higher rates. So one of the things that we always tend to think about as a possible capital gains tax planning tool is that if you've got an estate where you've dealt with the debts, you've got surplus assets, some of which are going to be sold, look and see whether it will actually save capital gains tax overall if you appropriate that asset to a beneficiary before you sell. Because once you've appropriated it to a particular beneficiary, you are holding on a bare trust for that beneficiary, and the sale that you make for that beneficiary, or beneficiaries in the plural, there's nothing to stop you appropriating assets to 3 or 4 beneficiaries. And then you also can potentially get the advantage that they each have an annual exemption, as well as the possibility of lower rates of capital gains tax. So it's quite a common thing for people to think about where there are assets that are going to be sold. And as I said, it can save capital gains tax because you will be paying at the beneficiary's rates, not at the personal representative's rates. So it's a way of saving capital gains tax. The other thing I'm just going to mention, and I sort of slightly draw a deep breath before I do mention it, but there was something on the Trust discussion forum recently where somebody raised a question about the Trusts Register. Now, the Trusts Register is nobody's favourite topic at the moment, but if you're holding property on a bare trust, that is a trust for the purposes of the Trust Register, and unless it comes within one of the exclusions, it has to be registered. So the question, this very innocuous question on the Trust discussion forum was, if we as personal representatives appropriate an asset to a beneficiary before we sell, we are creating a bare trust. Surely to goodness we don't have to solemnly register that bare trust on the Trusts Register. I was looking at it and I was thinking, dear Lord, that would be extremely inconvenient, but I can't quite see how you get round it. And then somebody posted an answer which said that on the tax agents forum, which you can only access if you are a registered tax agent, but on that forum, that question had been asked and the Revenue had responded. And they had said that there was an exclusion which could apply in those circumstances. Now, it's not at all an obvious exclusion. It's headed commercial transactions, and it talks about the situation where you have a trust to enable or facilitate a transaction which is being effected for genuine commercial reasons. So really doesn't seem particularly apposite for what we're talking about here, because the personal representatives could easily sell without the appropriation. But that's what the Revenue apparently said on the agents forum. And apparently the users committee that liaises with the Revenue about the Trust Register generally has raised the question of appropriations, and it looks as if the Revenue will either issue a statement in the newsletter, or more likely they'll add something to the Trust Registration Service manual. So it's a watch this space. We haven't yet reached deadlines for having to register trusts which don't have a tax liability. So there's no particular pressing need at the moment, but it is an issue which I am expecting there will be some guidance on in the not too distant future. That's slightly off the point, but I just raise it because you may have seen the question, or the question may occur to you: are we supposed to be registering these bare trusts? And the answer is probably not, but we'll wait and see.
Okay, great. Thank you. And James, and in your view, what are the advantages of using an IPDI on the first death rather than leaving the entire estate to the surviving spouse? Absolutely.
Well, this in a way comes back to the first question. Obviously, I did go slightly off topic on that. You know, for me, it is the asset protection element, especially for surviving spouses. Because what you're essentially doing is you are minimising the risk, and what you could say that you're providing protection for the surviving spouse, knowing that that person will be looked after for the rest of the life, but also protection for the children in due course. The risk is if you were to leave your estate absolutely to the surviving spouse, you've got the risk of remarriage, whether now or in the future, and that could then lead to a claim under the Inheritance Provision and Family Dependence Act, or a new will being made. Maybe not even remarriage. You could look at cohabitation. They may decide they don't want to get remarried again, but after 2 years, the point Leslie made, it may be an older couple who want companionship. They don't necessarily want to get married, but they live together for 2 years after death. 2 years together, and then one party dies. There could be a claim under the Inheritance Provision and Family Dependence Act in that instance. It also can protect against the lifestyle of the survivor. So if the survivor decides to turn to drink, drugs, rock and roll, whatever they want to do there, but also for the survivor deciding to disinherit a child. Later on in life, they may fall out with one of the children and say, well, you're not getting anything, and they cut them out of their will. The question I would always put to my clients in that event is, well, on the first death, is that what you would want to happen to your children? Just because the survivor decides to cut them out doesn't mean that the first to die wanted to. And then also it could be that the survivor changes the will and leaves everything to the local charity, the local donkey sanctuary, for want of a better expression. So it offers that certainty on the first death by using a flexible life interest trust, that the wishes of the first to die will be seen to in that the children would benefit in due course. And I've got to say, it's my favourite type of trust. I'm sure everyone has a favourite type of trust who's watching this. I'm sure Leslie's got a favourite type of trust, but for me,
this one.
It's great, and I find a lot of clients, when you explain this to them, they haven't actually considered the prospect of their husband, wife, or civil partner having a life after they die. But we're seeing it more and more in practice, where it will be second time around marriages, or you've got the situation where someone's died young and then there's been a remarriage, and it's the modern blended family. I'm sure I saw a stat that it's one of the fastest growing living arrangements in the UK. So I think for most married couples, a flexible life interest trust should be considered in all but the most simplest cases, because the prospect for damage being done later on, is so high. So it takes away the risk of leaving everything across on the first death, in my view. And I'm actually sometimes, being quite honest, quite shocked when I've done pre-pandemic days when we could actually do these in person, and you'll be explaining about a flexible life interest trust on the talks, and then speaking to delegates after who've not heard of them or not really used them. And they're just a great tool to have, in my view. And it just gives that, another point to consider, it allows for effective estate planning after the first death. If the surviving spouse doesn't need recourse to the trust fund, then funds can be released from the trust and they're treated as making a pet. So again, it allows that effective post-death planning. And now I feel like I've done a very good sales job for flexible life interest trusts. And I'm glad that Leslie is her favourite type of trust as well. It's not just myself.
I'm going to say two things. One is in wholehearted support of them, which is that one of the problems as people get older is that certain forms of dementia are quite insidious. And so you don't necessarily realize that somebody's suffering from dementia, but certain types of dementia, you get real changes in personality, and particularly sort of disinhibition. So somebody who's been very careful and prudent all their life might suddenly start spending really, really lavishly. So there's that kind of dementia. And then this isn't necessarily a dementia thing, but if people live to a great age, they can become quite crotchety. And they can also become quite vulnerable and subject to influence. I'm not saying necessarily undue influence, although it often does edge quite closely. So there are all those kind of problems which may lead them either to squander the money or to leave it, as you say, James, disinherit one child who they perceive as having upset them, whereas in fact they may not have done at all. So from a protection point of view, it's really good. And the reason we talk about them as flexible life interest trusts is that you always put in power both for the trustees to apply capital for the benefit of the surviving spouse if they need it. So something like private medical treatment, for example. But also, as you said, James, you put in this power to terminate their right to the income if they no longer need it. Because, for example, if they've gone into care, their care home fees are being met from other sources. You keep on paying the income from the trust to them. It's just going to pile up in their bank account and increase the IHT that's eventually paid when they die. So the flexibility is really, really useful. So all that's my wholehearted support. The only thing I'm going to say, just to bear in mind, is be a little bit careful if one spouse is much richer than the other. And the spouse who's the richer one is the one who's proposing to leave the property on trust. Because if the surviving spouse is unhappy and they think about making a claim under the 1975 Act, under the 1975 Act, surviving spouses and civil partners are entitled not just to reasonable provision for maintenance, but to reasonable financial provision. And what the court takes into account in deciding whether or not there's been reasonable financial provision is what they would have got had the marriage ended in divorce. And of course, since we had the House of Lords decision in White and White, you're approaching, a divorce situation, asking the question, well, why wouldn't we be dividing the capital up equally? So if you've got a situation where the surviving spouse doesn't have very much in their own name and hasn't been left any capital by the first to die, they're quite likely to be successful if they make a claim. And the most recent case was Cowan and Foreman, which was exactly this scenario. Very, very, very rich man who died. He made, good provision for his surviving spouse via discretionary trusts and a life interest, but he didn't give her any capital. And she was therefore, as she put it, totally dependent on the trustees, which she found very difficult. And although it was only heard on the basis of would she be given the right to apply out of time, which she was, the Court of Appeal did comment on the fact that they thought she had a good arguable case because she had no capital and she would have received capital had the marriage ended in divorce. So I would just say that if you've got the assets disproportionately held, you might want to consider giving some assets to the surviving spouse, absolutely. But I'd still use the flexible life interest trust as well.
Okay. And Leslie, where a property is being specifically gifted and the property is then increased in value and the PR sells the property, is it the beneficiary's responsibility to report the capital gain in their own tax return?
Well, yeah, because the personal, if you've got a specific gift of property to a beneficiary, then unless the gift fails because the PRs need the assets to pay debts, the beneficiary has a shows in action. As soon as the personal representatives say to the beneficiary, we don't need this in order to pay debts, it is yours. If the beneficiary says, oh, well, I don't actually want it, sell it, they will say, sell it on my behalf. So the sale is for the beneficiary. It's the beneficiary's sale. It's the beneficiary's liability to pay the tax.
Right. And James, what are the main advantages of using a discretionary trust?
So the main advantage of a discretionary trust really is the flexibility. That is the main thrust for me, and depending upon the type of clients, the flexibility can be used in different ways. But basically speaking, a discretionary trust doesn't confer a right on someone to the income or capital of the trust fund, just what I'd say mere hope of benefiting should the trustees exercise discretion in their favour. So by doing that, it can offer a significant degree of flexibility and also asset protection. So if you've got a beneficiary who may or may not have alcohol or drug issues, indeed one of my old clients had been living in a commune for 20 years and quite readily said that if she had been given the keys to the trust fund, it would have disappeared while she was there. Safe to say that the family funds were kept well and safe because the trustees never exercised discretion in her favour. But if there are issues, if it could be that a child could divorce, require care, maybe you've got a child who is disabled, then assets could be used for their benefit without them being taken into consideration. Also, because a discretionary trust sets up the pool of potential beneficiaries, for certain clients, it can offer a great degree of privacy. So it may be you've got a higher net worth client who doesn't actually want it to be apparent on the face of the will who is to inherit from their estate. So what you would do in that instance would be using a robust letter of wishes, whereby you would be able to say to the trustees, this is what I would like you to consider doing, and set out who gets what at that stage. From a client's point of view, as we discretionary trust in their will, they would be able to make changes without having to change the will, so they could change the letter of wishes. And if a client was to do that, you'd obviously want to get them to send you the updated versions of the letter of wishes as well. So the great benefit is for the protection element and the flexibility, but also for the beauty of your clients being able to change what they want to do without having to incur the cost of changing the will, which, if you've listened to the marketing webinar that I did, you were thinking, well, that's exactly the opposite of what you were saying in your marketing webinar. But again, it can be a good way of building that client trust as well. You have done this, you can change your letter of wishes without having to change your will, should you so desire. And that will, I found, breed a bit of client loyalty there. But yeah, depending on the value of the estate, there can be disadvantages of a discretionary trust when it comes to inheritance tax, income tax, CGT. But that should all be weighed in when you're giving your advice. Another option with a discretionary trust in the will, you could use a 2-year discretionary trust, which gives you that wait and see provision. Because within that 2-year period, you are able to transfer assets out of the trust, which in effect rewrites the will to put into effect those distributions. But you can see how the family operates, I would say, or how the family copes after death. and see how it all works. So discretionary trusts are great in the right circumstances. And for me, the main advantages will be the flexibility and the protection that can be offered.
I think it depends what you're comparing, really. Because, of course, if you've got a surviving spouse or a civil partner, then you can pass everything into a flexible life interest trust without any tax being paid at the beginning. So it's unlikely that you'd choose a discretionary trust for your entire estate when you had a surviving spouse and you could make use of the spouse exemption. But there's a lot to be said, I think, for even these days when we have the transferable nil rate band, there's still quite a lot to be said for creating a nil rate band discretionary trust, because you shelter those assets within the trust. You don't have an immediate liability to inheritance tax, which is what tends to put people off. And then you've got the potential for growth in the value of those assets outside the estate of the surviving spouse. Because although people always think that, the inheritance tax regime on relevant property trusts, it's really unattractive. Actually, it's not that unattractive if you've got a trust which has inherited a full nil rate band, because what you find is that the level of charges on exits and anniversaries is really relatively low if you've got the benefit of a nil rate band. So, and if you compare those relatively low charges with a 40% rate if those assets are inside the estate of the surviving spouse, it actually makes the discretionary trust look a cheaper option, subject to all the paraphernalia of having your trust up and running. But a lot of that you can get round by, making your administration as streamlined as possible.
I think that's a really good point about the 10 yearly charges. I think it's how it's put across to your clients. So what I've been doing in practice, I'll work out a 10 yearly charge for them, but then you divide it by 10 and say, say for example, the 10 yearly charge is £15,000, for example. I would say for £1,500 a year, are you happy to have this protection? And psychologically to the clients, they'll see that, say, actually, I'm happy to pay £1,500 a year for that. I just don't like paying £15,000 then. But it's the way they look at it.
Yeah.
And most clients are quite amenable to the suggestion once they've looked at it from a different angle.
The other thing that came into my head, but I think we probably shouldn't go chasing rabbits because there might be a specific question coming up about this, but you did mention disabled children and a discretionary trust. And of course, there is the alternative of a disabled person's trust, but perhaps we'll wait and see if we get a question on that.
Yeah, I think it's something I picked up on in the webinar, Leslie, on that. I think it's, again, with all these things, it's being aware of the options available and then choosing the right one for the specific circumstances. And this is one thing that really gets to me, is when people still look at wills as a low-cost commodity when actually they're not.
Absolutely, couldn't agree more.
Okay. Great, thanks. And then Leslie, can you appropriate to non-domestic beneficiaries, for example, in the USA for capital gains tax purposes?
I got this question recently, and I'm going to give the same answer, which is that I don't see why not. I can't think of anything specific that says that, and in fact, I can't see how there could be anything which says that you can't appropriate an asset to a non-UK beneficiary. So I would say, yes, you can. They will take the asset at market value at the date of death. And then you go from there and see what your situation is.
Great. And James, in your webinar, you mentioned internal marketing. How is this best done?
So moving now on to the marketing section of what it. So with the internal market, I find in most law firms, it is completely untapped. And I say that from being in the last two firms where we've been a small little department in massive firms, maybe less than 1% of revenue in one of them. And I think really it's making other departments, other teams aware of what you do and why you do it. What is the story of the department and how does it help them? So, for example, it's making sure your colleagues who maybe deal with divorces are aware at an early stage that, we may want to advise our clients to make a will, just in case they die during the process of divorce. And the way that you do that is either go to their internal team meetings and provide them with that knowledge to help signpost the client to you. And at times you can do that by highlighting the risk to them of, do you think the family would be happy if you don't advise? Would your client be happy with his or her wife, husband, civil partner, who they're divorcing, inheriting money should you die during the process of the divorce? Again, it's making sure they're aware of this. Other things could be as if you're dealing with dispute resolution teams who are dealing with claims. They may or may not know that if the client dies during the process of the claim and there is no will, they're a bit hamstrung because they don't have a client. Whereas if there's a will in place, even if it's just a simple will, they've got a client because the executor's role will speak from the date of death, whereas the administrator's role will speak from the date of the grant. So by educating and showing the risks to them personally or as a team, then that will get the engagement. Also, if you're dealing with corporate commercial work, explain how wills, powers of attorney can help their clients, increase the client's engagement with the firm, and really take ownership of that client. Your client won't be happy. Say, for example, if they're selling the company, and the lawyer doesn't say, so you might want to speak to our trust department. You may want to set up a BPR trust. You may want to do this. And then when they realise they've missed that opportunity, they won't be happy with the firm. So really, it's engaging with the teams and showing how you are essential to them. At the end of the day, we are all going to die. It's not a question of it's when and how. That's what comes into it. If I'm going to be so forthright by saying that, but we are integral to everything the firm does. And to me, it's making sure that the private client department becomes the beating heart of the firm. And if that doesn't work, buy them cake.
I'm going to add two things to that. First of all, there's quite a well-known case where, and it was a big firm, and they had a big commercial department, but they also quite a well-known private client department. In the commercial department, chap was selling off his business, making a very substantial capital gain. So there was going to be a capital gains tax liability. He was known to be not in great health. He was known to be going to have, there was some discussion about whether you should describe it as an operation or a procedure. But anyway, he was going to have some medical treatments, and he was then going to retire to somewhere like Thailand, where he thought that the climate would be better for his health. So the firm sells the business, thereby crystallizing the capital gain. He goes from having shares which were eligible for business property relief to having a big chunk of cash, and he dies almost immediately after that sale. And his family are very unhappy, as you can imagine. And they say, well, why didn't anybody give him any IHT advice? Because, there he was with no IHT liability. Now we've got this huge IHT liability, and on top of that, a capital gains tax liability. And the argument was, had the firm been negligent in not providing IHT advice. And they looked at the terms of the retainer, and the judge said, well, this retainer could have been more clearly drafted, but actually, I think that you had sufficiently narrowed down what you were doing, so you're not actually liable in negligence. Well, the family is still very, very unhappy. But the thing that really caught my eye was when I was reading the report, the judge quoted from the commercial partner who had been managing the deal, who said, I couldn't possibly have undertaken to give any IHT advice because I know nothing about IHT. And I thought, well, A, that's pretty shocking if you're dealing with clients whose businesses attract business property relief. You ought to at least have known something. And you ought to have known that there's an issue here. We've got this big, well-known private client department. Why on earth wasn't it passed across? So I really think there's lots of scope for interdepartmental liaison and also education. I mean, you know, I was doing an actual face-to-face course this week, which was a delight. And we were doing the trust register, and we must have spent, easily 3/4 of an hour talking about co-ownership of land and when you did and when you didn't have to register the trust. And somebody said, do we think our property departments are actually engaging with this? And general feeling in the room was that they probably weren't. And that, you know, a brown paper bag lunch with a, you know, a talk by the private client lawyers on, you know, the trust register might be quite useful.
Yeah, it amazes me that I think every department just lives in its own furrow, you know, and really it's trying to get involved with them, and you know, even if it's just having a cup of coffee and a chat, or doing the educational pieces, run some seminars.
Undue influence, that's the other one that I keep noticing, because I think private client lawyers have really quite good antennae for undue influence. But I can think of a number of cases where, you know, typical scenario, adult child brings mum to sell mum's house or transfer mum's house into their name. And there are other siblings around. And I think property departments, this is a huge over-exaggeration, but I think property departments can be quite transactional. So somebody comes in, they say, we want to sell, we want to transfer the title to, and the person who's dealing with it does it. Whereas you would hope, as you were saying with the wills, that, you know, you would explore things rather more in the private client department.
Yeah, and see whether there's different options that can have the same outcome.
Yeah. Okay.
Right, great. I think we've only probably got time for just one more question, if that's okay, guys, just before we wrap up. So Leslie, does Trustee Act 1925, Section 32 apply to all trusts?
Okay, Section 32 of the Trustee Act is the section that gives trustees power to apply capital for the benefit of beneficiaries. Now, it applies unless it's excluded, but it virtually never is excluded. But it only gives trustees power to apply capital for the benefit of beneficiaries who have an interest in capital. So if you have the kind of trust that James and I have been talking about, the flexible life interest trust, your surviving spouse who's entitled to the income, or your surviving civil partner who's entitled to the income from the trust, they have no interest in capital. So the trustees have no power under Section 32 to apply capital for the benefit of the surviving spouse or civil partner, unless the trust gives them that right, which in a well-drafted flexible life interest trust you would. But with that flexible life interest trust, you know, to my wife for life, remainder to the children have got interests in capital. And therefore, Section 32 does give the trustees power to apply capital for the benefit of the remainder beneficiaries, because they have an interest in capital. So it applies to all trusts unless it's excluded, but it only gives the trustees power to apply capital for beneficiaries with an interest in capital, which is why you would often put in an express trust or an express power to widen the trustees' powers to apply capital. Do you want to add anything, James?
No.
Okay, well, I think that's we're nearly out of time, so that's everything for today. So thank you ever so much, Leslie and James, for taking part today. And just to let people know that are watching, that if you've purchased the online courses, there's still time to watch the pre-recorded content. The expiry date will be displayed next to the webinar. And for those who haven't purchased it, there's still time to buy. What you need to do is just go up to www.thesolicitorsgroup.co.uk, where you'll find the online exhibition, and the exhibition is open for everyone to visit. And if you book the entire package, you can claim your 1 hour free CPD webinar. And finally, after viewing the online course, please complete the feedback form that is available in the related link section, and you will receive your CPD certificate via email. So thank you again for today, guys. Is there anything else that you want to add, just as we're closing up?
Don't think so.
No.
Well,
no? Right, well, that's brilliant then. So thank you everyone for watching, and thank you again to our experts, and have a great day. Thank you.
Bye.
bye.
Bye.